Three, two, one.
Good afternoon. For the record, my name is Jonathan Kwan. I'm chairman of the Criminal Law and Procedure Review Commission. We are here for a plenary meeting of the commission. It is now 12:04, January 29th, 2026, and this meeting is called to order. I note for the record, we are in person in the Judge Joaquin V. Manibusan Senior Memorial Courtroom in the Judicial Center. We are on Zoom for those members who are not able to attend in person. We're also live on the Judiciary's YouTube channel. As this meeting is being recorded to avoid background noise, I ask that members appearing by Zoom to please mute yourselves unless you are speaking. And if you are here in person, please wait until we position a microphone before you speak. Next slide, please. On agenda 2, due notice, I note for the record that due notice of today's meeting has been provided pursuant to the requirements of the open government law. Copies of the newspaper notices are included in your packets. Agenda item 3, determination of quorum. We'll start with a roll call. Members who are here, when your name is called, please state present and the location you are appearing from. May I ask the CLRC Administrative Assistant, Lisa Banas, to please call the roll.
Honorable Jonathan R. Kwan.
Present. Judiciary Guam.
Honorable Maria T. Senzon. Honorable Anita A. Sacola. Attorney William Bucky Brennan.
She's muted, but she's here.
Yeah.
This is Bucky, present from my office in Agania.
I'm here. Thank you. Present. Present. Sacramento, California. Sorry. Thank you.
Department of Corrections, Fred Bergallo or designee Major Anton Uggen.
Present. I'm here over at the Department of Corrections in Manila.
Chief of Police Stephen Ignacio or designee Sergeant Michael Elliott.
Sergeant Elliott is present and
Attorney Joseph B. McDonald.
Present at the Judiciary.
Attorney F. Randall Cunliffe.
Present at my office in Agania.
Mr. Monty McDowell.
Present. Judiciary Guam.
Attorney John Morrison.
Present from my office in Sinahani, Guam.
Assistant Attorney General Valerie Nuesa.
Present from my office in Agania.
Attorney Michael Phillips. Miss Valerie Rages. Attorney Christine Tenorio.
Present from my office in Agania, Guam.
Attorney Philip Tedinko. Ex officio members, CLRC Executive Director Serge Kanga.
Present at the Judiciary.
Compiler of Laws Jerry Cepeda. Present at the Judiciary. Mr. Chair, we have 11
votes.
commission members present.
We have a quorum?
We have a quorum, Mr. Chairman.
Thank you. I ascertain that we have a quorum and can conduct the business of the commission at this meeting. I would like to, just to make sure that everyone's aware that Chief Justice, the new Chief Justice is Chief Justice Catherine Merriman, who is now the Chief Justice of Guam and will be providing and has been providing the continued support. I'd like to thank outgoing and former Chief Justice Robert Torres for all the assistance he provided during his term, and we look forward to and are grateful for the continued help that we'll be receiving from the judiciary. Now let us proceed. On item agenda 4, let's go through the minutes of October 8th, 2025 plenary meeting. These minutes were provided in the meeting packets for members' review. May I have a motion to approve the minutes? I move that you approve this rate. Thank you. We have a second?
Second.
Any objections? There being none, the minutes of October 8th, 2025 are hereby approved. Let us move on to agenda item 5, old business. On agenda item 5, please put the next slide, slide 3 on. And I ask the executive director to provide his report on these items.
Thank you, Mr. Chairman. I have two items to report, and I'll start with the status update of the commission's work. I would like to welcome everyone to the first plenary meeting of the year for the CLRC. I too would like to acknowledge our new Chief Justice Merriman. I would like to introduce our new research attorney, Yusuke Hafuman Udagawa. He comes to us from the AG's office, where he has done civil, criminal, and child support work for around 3 years. Then he spent 2 years or so in the private practice doing criminal defense, civil, and transactional work. So we welcome him along with our other two part-time research attorneys. We stand ready to do any research that any commission member would like to have done. Between the four of us and Lisa, we are ready, willing, and able to take on whatever research task that you have of us. And we'll be taking more of a central lead in some of the subcommission's work moving forward. Speaking of the subcommission's work, we have until January of 2027 under our enabling law to complete our mandates established through that law. We have until that time, unless we go to the legislature and ask for more time and an additional appropriation, which is undecided at this time. So we are moving forward as if we will have until January of next year, 1 year from now, to get everything done. The next thing is I will be sending all subcommissions an update of pending Title IX chapters within the week. Our fourth quarter report for 2025 will be issued within a week or two. Can I have the next slide, please? Okay, moving on to the interim report updates and the notice of errata and revisions. I'll provide the background and history of these items. If you recall, our interim report was approved in May of last year by the Plenary Commission, and we sent it to the legislature in June of last year. So in November, the legislature introduced Bill number 232, which purports to adopt and approve all of the recommendations that we placed into the interim report. In mid-December 2025, we were asked by the legislature to review Bill 232, and in doing so, we noticed and became aware of a few errors in the bill.
If I could interrupt, I'm sorry. Bill 232 is an omnibus bill. It is huge. It contains all of the work we forwarded. So it is a huge bill.
It's a rather large bill, yes. You're right, Mr. Chair. So in our review, we noticed a few errors in the bill, which were a result of some clerical errors on our part, but also we noticed that revisions need to be made because of amendments made by the legislature after we sent the interim report to them in June of last year. So in your packet, there is a draft notice of errata and revisions, which we sent the other day for your review. This notice of errata and revisions corrects the discrepancies in the interim report, and then we'll correct the discrepancies in Bill 232. We will submit for approval this notice of errata and revisions at the conclusion of my presentation and any discussion that follows. If we do get it approved, it will be sent to the legislature immediately, sometime next week. Next slide, please. So this table, which is included in the draft notice sent to you, summarizes the sections covered in the notice of errata and revisions. Most of the revisions, as you can tell, 7 in total, are necessary because of subsequent legislative amendments to sections that were in the interim report. 3 of the sections were rendered no change because of compiler of law changes that were already in place. 5 sections contain our own CLRC clerical scrivener errors, which include errant editing, marks, version issues, and other human errors. Note that the interim report contains literally hundreds of sections and around 24 chapters that were covered from Title IX. Next slide, please. To start our review, Sections 1.18, 1.19, and 1.20. These sections were recommended for non-substantive changes, which would remove the word territory for consistency with 1 GCA section 420. However, the compiler of laws had already made those corrections and our recommendations were rendered moot. So what we'll do is replace the current sections into the interim report and change the CLRC comment to no change. Next slide, please. So there is, we found, a clerical error in section 16.50A2. The section in the interim report did not correctly reflect the Commission's approval of the recommendation for this section, which was simply to remove the parentheses as shown here and keep this language in this subsection A2. The initial recommendation, you might recall, was to remove the parenthetical to its own subsection, but the Commission decided it was better to keep it in A2 without the parentheses. So the correct section will go into the interim report. If you have any questions or comments on any of these, please let us know. Okay, moving on to the next slide. Section 19.82. This is a new section added by the legislature in Public Law 3870 after the interim report was submitted to them in June of last year. We will place this new section into the interim report with some minor spelling and punctuation errors, which you see up on the screen here. Misspellings and abetting, small things like that will be corrected. Next slide, please. So in this section 25.10A, this was amended by the legislature in Public Law 38-16 after the interim report was submitted to the legislature. Two of the legislature's amendments, relationship by blood and infinity, closely tracked our own recommendations. Our new recommendation will keep the new legislature's amendments, while adding the word consanguinity to A12 as you see highlighted here, and then adding the definition of cunnilingus as we recommended in the interim report sent in June of last year. The Public Law 3816 also added definitions for dating, relationship, and adoption, which in deference to the legislature will not change because they are so new. Next slide, please. So these two sections, 25.15 and 25.20, were added by Public Law 3816 after the interim report was submitted to the legislature. Our report contained no recommendations on these sections. However, since we included chapters in their entirety, we will update chapter 25 in the interim report with these sections. Next slide, please. On section 25.25, this again was amended after the interim report was submitted by Public Law 38-83. The interim report made no changes to this section, and we will update this section in the interim report. Next slide, please. On section 25.50, again, this is a new section which was added by Public Law 3870 after the interim report was submitted to the legislature. We will add this new section to the interim report with non-substantive spelling and punctuation corrections, similar to the section that was presented earlier. Next slide, please. In section 31.30, we found clerical errors in the interim report, which did not correctly reflect the Commission's recommendations for this section, which were approved orally during the plenary meeting on this section. As highlighted here in subsection A2, willfully causes or permits any child to suffer was not struck through, which should have happened. And in D1, the word willfully was replaced with the word intentionally. So we'll make these corrections and insert the corrected section into the interim report. In 34.50, the interim report has the word another, which was inadvertently struck through. So we will correct the strike through and include the word in another, and the corrected section will then go into the interim report. In 34.60, another clerical error. The highlighted term that you see here, results in, was inadvertently omitted. The corrected section with the words result in as highlighted here will go into the interim report. On section 34.70, this section was amended by Public Law 38-78 after the interim report was submitted to the legislature. In deference to the legislature's recent amendments, which concerned enhanced penalties and fines, we will withdraw our recommendations that conflict with the new amendments made by the legislature. However, as you can see here in this subsection A3, we'll keep the added language or the Department of Land Management. We'll make these changes and the corrected section will go into the interim report. For section 70.65, again, we found a few clerical errors. These concern renumbering. So we'll simply renumber the sections correctly and insert the corrected section into the interim report. Next slide, please. So in summary, most of the revisions are due to recent legislative amendments and additions. We did find a few clerical and editing errors, most of which were non-substantive. While we feel that even one clerical error is one too many, we are motivated and we will do better to catch these moving forward. Now, while we were talking, next slide, please. While we were talking about legislative amendments affecting our review of Title IX sections, if I can take a moment, I'd like to show the Commission this table of bills that could affect Title IX. Bills 162 and 138 are currently being considered in the present legislative session. We'll track these bills and any others that are introduced and keep the Commission informed. So with that, I submit the notice of errata and revisions for approval so that it may be transmitted to the legislature as soon as we can. I'd ask if there's any discussion on any of the sections that were presented in the interim report.
Is there any discussion? Anybody have any comments? No comment. Anyone?
Okay, I have a question here that how many sections total in the interim report were reviewed? And I did count that, and I believe there are 124 sections that were actually amended in the interim report, and hundreds more that were included as reviewed.
And no change.
So let me explain to those that are new, let me explain the process we've been using for the past 3 years. The subcommissions are assigned their various sections to review, and they do so in an orderly fashion. We leave the running of the subcommissions to the subcommissions chairs and their committees. They have 3 possible options. One is to recommend repeal. The second is to recommend amendments, and they'll provide those amendments. And third, no change. So we are talking a total of 120 have been reviewed and have recommended either repeal or amendments. Is that correct, Mr. Executive Director?
Yes, that's correct.
Plus another about 300?
More or less, yes.
300 that have have been reviewed but have recommended no change. Is that correct?
That's correct.
Now we've had a total of 4 clerical errors, approximately.
5 clerical errors.
5, okay. Oh, shame on you, 5. Instead of the 4.
Unforgivable.
5, okay, so 5 out of 400 sections, all right. It's still, I think it's still a passing grade. Is there any discussion, anyone?
Oh, and thank you for catching those errata.
Yeah, thank you. I wish to note that it should be noted that the legislature is passing laws much faster than we can review them. So I want to put it in the context of we're getting through the sections, we're reviewing it, the subcommissions are arguing them out, they're presenting the recommendations of the commission, but the legislature has already passed or proposing 3 or 4 bills affecting some of the sections we've looked at. So we cannot keep up with their proposals.
Just, I have a comment,
Yeah.
actually. I guess, first of all, is there any thought to reviewing what they recently passed?
That has been requested.
Okay.
We have not decided
Okay.
collectively on what to do with that.
And then secondly, I think this is an old point, but it would be good, I guess, if for criminal substantive and procedural statutes, if it's run through a permanent commission,
Agreed.
before the final vote is taken at the legislature, that way it can be harmonized and then we wouldn't have this duplication or potentially a conflict in a conclusion or, this is something we've discussed, I think, before, but yeah, I'll just put it on the record again.
And along those lines, Attorney McDonald, we've had some very preliminary informal talks with some at the legislature on a permanent commission similar to what we are now.
Not us, but another commission. Right.
It'll have to be established in a different piece of legislation.
The other idea that you might consider is inviting legislative counsel to these commission meetings.
He is. Mike Phillips is one of the members.
Right.
Right, but it's the same firm, right? He's the.
That would maybe shortcut some of this.
Right. Yeah, and yeah, Mike is a named member of the commission.
Gubernatorial appointment, speaker appointment.
Yeah. Yes, speaker.
Okay. The only concern I have, and I've expressed it to the executive director in our discussions, is if we contemplate reviewing proposed bills that or laws that affect the sections we have already reviewed, we'll never get done. As it is now, we're firing on all cylinders, working as hard as we can. If we add that additional review as in real time, I don't think we're going to get finished in any reasonable amount of time.
This is Jerry, just as a point, I mean, the fact that they're introducing and we discuss that as a commission doesn't mean that it's still not going to be amended after hearings in committee.
That's correct.
So we literally would never be able to catch up, except for the 10 days after it's submitted to the legislature, to the governor. That's the only time we'd know that they're really done.
And I would add too that the sponsors of the amendments of these bills that are before the legislature that could change Title IX sections, they all have the interim report, and they're at least constructively aware of sections that we're working on or have recommended changes to. And again, as Jerry pointed out, everything that we've recommended to the legislature is still going to be subject to changes made at the legislature during public hearings and so forth. So everything is still on the table. There's nothing that we're submitting that is set in stone until it's actually approved in law.
But we're reviewing the laws from eternity up to now.
Right.
We just state that from when we submit, anything past afterwards is not in our jurisdiction, so to speak.
I think we have to do that so we can get our work done
and finish it.
I mean, the nature of these commissions in many jurisdictions are an ongoing concern. So
as I understand,
because they never touch it while we're working on it. That would be the only.
Yeah, I don't think we're gonna.
So as I understand the current stage that it's in, they're just awaiting our proposed errata, if the body agrees, that'll be sent, it'll be included into the current bill, the revisions, and then it's gonna go to committee. That's where I believe it is right now, right? It's gonna go to committee?
Yeah, that is my understanding also. Our review of Bill 232 is on hold until we get these changes made to the interim report.
If you agree.
And then we'll incorporate the changes made here that go into the interim report into Bill 232.
Then it goes for the committee and then
Right.
public
Public
hearing.
hearing.
Then we return the bill to the legislature for whatever needs to be done on their side.
A reminder that this is supposed to be, I believe, a halfway point.
We're past that.
Yep.
So we're way past that problem. And this is, we get in, they get it approved, then that shows that this committee has done what they've asked us to do and they passed it. If they don't pass it, pretty much might as well get rid of the committee. What are we doing?
Well, we'll see what they do, but it's
Right.
moving forward.
Yeah, and so they're gonna pass it and then we just continue on. Hopefully we finish this year.
Any other comments? Anyone?
Yes, if I may,
I-
Your Honor. Oh,
Mr. Cunliffe?
Go ahead. Well, yeah, I just, if I understood Serge correctly, they're going to include in this proposed bill statutes that have been amended after we started reviewing. And if that's the case, that they're going to be included, could we put in a note that we didn't review these for any change? So that they're aware when they look at it that we haven't touched them.
It's a notation
Just a
not
note.
reviewed by
That's
CLRC.
An asterisk.
a good point, Randy. We'll certainly put that into the CLRC comment for those sections.
Thank you. That's an excellent point. Attorney Tenorio, good?
Yes, so is there a way we can, even if we're not gonna be, that this commission is not tasked with reviewing the bills as they're coming in, sometimes we're already working on it. So just for everyone's knowledge, the reason why the consanguinity and the definition of cunnilingus was put in there was because I took our committee's report and I gave it directly to them because they were in the middle of changing the law. So rather than do it piecemeal, I gave it to them, but my subcommission was aware of that. So is there a way we can do kind of like current events or segment in these commission meetings where I think that would have been a good update for the commission to know, so that we just can see how currently, like just the way Serge put up the bills, the current bills that are being contemplated, just so that we know how it's affecting the current work that we're doing and the reports that we're submitting.
That's a good point, Christine. Thank you for that. That was my intent to do moving forward at
Okay.
our next plenary meetings. I'll be reporting out on any bills that have been introduced and even passed by the legislature that affect our review of Title IX sections.
Okay, great. Because even that section that you put in, the interfering with the report of criminal sexual conduct, no one told me that, and I'm the one that's prosecuting it. So, but it's helpful because now that we've addressed that information in this meeting, then we all have a better understanding of how we're treating our chapters because my subcommission was assigned to that section.
Will
Thank
do.
you.
Excellent suggestion. Any other discussion? All right. If there's nothing further, do I have a motion to approve the errata as presented by the executive director?
So move.
That also will include the suggestions by Attorney Tenorio as well as Attorney Cunliffe. Is there a second?
Second?
Is there any objections?
None.
There being none, it hereby passes. Please forward that to the legislature as soon as possible so that we can get that into bill format and get them moving forward. Thank you all for that. The notice will be transmitted to the legislature as soon as possible. All corresponding sections in the interim report and bill are replaced as presented. All right, before we get into the next section, slide 20, I want to recognize the new Chief Justice, Justice Merriman is online. Welcome, ma'am, as well as Senator Tello Taitagui's office is also monitoring. Thank you. Let us move on to slide 20. We are now under the new business. Agenda item 6A, the Subcommission on Criminal Procedure. It is my understanding that the Executive Director will present on behalf of the Chair, Subcommission Chair Judge Sokola. Attorney Kanga, please proceed.
Yes, thank you, Mr. Chairman. So we'll be addressing and discussing this section, section 7.86B, which we discussed at length in the last plenary meeting in October 2025. So we have Gordon Anderson, who is a part-time research attorney with the commission. He has a PowerPoint presentation and will lead the discussion on this. So Gordon, you may proceed.
Good afternoon. Can everyone hear me okay?
Yes.
Great. Can we move to the next slide, please? So this is a new proposal for 9 GCA section 7.86B. This is the deadly force statute that we talked about in some detail back at the October meeting. We'll recap that very quickly and then I'll move into the proposal. Can I have the next slide, please? So this is 7.86B right now, and it provides the use of deadly force is not justifiable unless the defendant believes it's necessary to protect against a couple of things. We have death, serious bodily harm, kidnapping, and then we have the highlighted term rape or sodomy. This is something that the Crim Pro subcommittee wanted to change because rape and sodomy are not terms in Title IX. We don't have offenses by these titles, so we wanted to change, or the Crim Pro subcommittee wanted to change it to criminal sexual conduct. Next slide, please. So this was the October proposal. You can see it was a straight substitution of the phrase criminal sexual conduct in place of rape or sodomy. But there was quite a bit of discussion at the meeting from the CLRC members who suggested that this might broaden the statute because the term criminal sexual conduct refers to a variety of sex acts, sex crimes, including fourth-degree CSC, which involves sexual touching. It can occur over clothes. It's always outside the body, and it seems to be somewhat different than what the 1976 Commission probably had in mind with rape or sodomy. So there was some discussion about whether we should limit it to only certain degrees of criminal sexual conduct. But I think there may be a different way to come at it. So on the next slide, here's my proposal. You can see there's 3 changes, and we'll go through each one individually afterwards. But the first one is to change the former phrase serious bodily harm to serious bodily injury. The second is to change the former phrase rape or sodomy to sexual penetration compelled by, and then the third change is to use the phrase force or coercion rather than force or threat. So now going through those individually, next slide, please. Here's serious bodily injury. This is not a significant substantive change. Serious bodily injury is just a term that is defined already in our code at 9 GCA section 1610C. It almost certainly has the same meaning as serious bodily harm, but it is a defined term, and it, as shown in the bottom half of the slide, it's more common in our violent crimes. It's also used in the deadly force defining statute. So this change would just be to use a term that already has a definition. I think it would be easier to administer if the court could refer to a specific definition of what this means. Then on the next slide, here's sexual penetration. This one maybe is somewhat more debatable. But starting with the term rape or sodomy and what those terms would have meant in 1976 when the commission was putting the statute together, I submit that that's probably a reference to crimes of sexual penetration rather than sexual touching. So if we make the change to sexual penetration, we have a definition for that in 9 GCA section 2510A10. And so my thought here is that making this change, in addition to using a defined term, would not dramatically change the meaning of this portion of the statute, that the phrase sexual penetration by force or coercion has the same meaning as rape or sodomy by those same things. And then in the next slide is the force or coercion change. This was from force or threats before. The phrase force or coercion as a compound as force or coercion is defined in 9 GCA 2510A3. It's also used throughout the CSC offenses in 9 GCA chapter 25. You can see I've highlighted like in section A3A, that is overcoming the victim through the actual use of force. In B and C, that's using threats in order to execute on the offense itself. So I think that force or coercion does not have a significantly different meaning than force or threats, but the big advantage is that the exact phrase force or threats only occurs in this statute, whereas the phrase force or coercion occurs throughout 9 GCA and is defined. So for all three of these changes, we're trying to do two things. One is to use a term, actually, can I have the next slide, please? It's on here. One is just to use a term that is more common. Force or coercion is more common than force or threats. Serious bodily injury is more common than serious bodily harm. And then all of them have an explicit definition too, which, like I said, I think would be easier for the courts to administer if they could go to a precisely defined term rather than trying to figure out whether the term used in 7.86 has the same meaning as a similar term somewhere else. So part of the proposal is to use a well-defined and common term. The other part is to not, at least to attempt not to broaden the scope of the defense, not to run into the problem we ran into in October, where we nearly accidentally made a pretty significant broadening of the statute. Just to quickly recap, I think serious bodily injury and serious bodily harm have the exact same meaning. I think sexual penetration by force or coercion is equivalent to rape or sodomy by force or coercion. And I think the phrase force or coercion is maybe slightly broader than force or threats because it brings in a couple of less common exemplars in the statute, for example, through medical battery or through an act of surprise. But I don't know if that's dramatically different than force or threats as written. So in short, I'm thinking that these changes will not significantly affect the substantive meaning of the statute. It'll just make it easier to administer. Give the next slide, please. One of the things we talked in detail about was what about the case of second-degree CSC? This, I think, in the October meeting, some of the members suggested that this ought to be a circumstance that would give rise to deadly force. This proposal would not inherently include second-degree CSC because second-degree CSC is not characterized by sexual penetration. But a couple of counterpoints that I wanted to make to that is that, first of all, second-degree CSC isn't included in the statute inherently right now, that the phrase rape or sodomy probably wouldn't include second-degree CSC, so it's not making a change to exclude second-degree CSC, it's just keeping the status quo there. The second point is that even if it's not inherently included, there are some factual circumstances where second-degree CSC would still invite deadly force if there was a threat of serious bodily injury. Two examples there. Sometimes second-degree CSC is accomplished through the use of a deadly weapon. Sometimes it causes personal injury. So in certain factual situations where second-degree CSC would involve or threaten serious bodily injury, deadly force would still be available in those cases. It just wouldn't inherently be included through the sex crime exception. And then I also want to note this. Can I go back one? Sorry. A point that my colleague Andrew Strage has made and I found very persuasive is that the statute is only discussing deadly force, which is force that is either intended to cause death or that is practically certain to cause death. This isn't going to change anything about the use of non-deadly force, proportional force in the case of second-degree CSC. A victim in that case can always use proportional force. It's only really a question of are we authorizing them, for example, to shoot the attacker in the head or in the chest, as opposed to pushing them away or using any other sort of force that would normally be involved or that would normally be permitted in a case like this. So it's a pretty narrow subset of force that we're talking about in this situation. And our overall take was that I think it's probably better for the statute not to, even if the statute is slightly under-inclusive, that may be better than going too far and trying to define as many situations as possible, only to open up unintended consequences that way. So there's certainly room for discussion about whether we should find a way to include second-degree CSC, but that's not included right now. So that's something that I would throw to the committee to discuss. And then on the last slide here, just to reiterate the three changes we're proposing. The first was to change serious bodily harm to serious bodily injury. The second was to change rape or sodomy to sexual penetration. And the third was to change force or threat to force or coercion. Again, all of which are defined terms in Title IX. So with that, I guess I'll ask if anyone has any questions or comments.
I do, if I can weigh in.
Sure.
Please.
Okay. So I'm the head of sex crimes right now, so this is directly relevant to my line of work. So I actually reviewed this as well because Attorney Huffman-Udagawa asked my opinion. I think if we're trying to go with the original intent and mirror the model penal code, I do believe that the suggested amendments would closely mirror that. I actually don't think that it was meant to apply to contact. So I don't think it was ever meant to apply to second degree CSC or fourth degree CSC. But the only issue that I can come up with is right now, even if we adopt sexual penetration compelled by force or coercion, this is not going to include rapes against children. So, for example, when we can charge someone with having sexual intercourse with a victim who's under the age of 14 or who is 15, under the age of 14 or 14 and 15, depending on the degree, right? But why I think that's a little bit problematic is based on how the victims are treated, they a lot of times if a child is being repeatedly sexually assaulted, they stop resisting and because they're scared and they're afraid and they're children. So if you stop resisting, it's no longer force or coercion under the current body of law. And so basically, we are saying that a child could never use deadly force against a perpetrator who had been repeatedly sexually assaulting her or him if they stopped resisting. So that's the only issue. I understand that this is never going to be inclusive of every situation, but I think that is a fair. I think that it's fair to include that, and we can hash that out, flesh it out more thoroughly. But that's just my take on the situation. If we're going to change it now, we may as well change it to include the victims who are vulnerable, not just by force or coercion. That's all.
Specific. Sorry, this is Jerry. Christine, would you think that would be solved by identifying the specific criminal offenses? So specifically identifying CSC first degree and third degree, since those are the only two that include penetration as an element of the offense?
I think so, because I do think so. The only issue we'll run into that potentially is if it's I think it can, and then there has to be a clause that says, but it wasn't consensual. And the reason why I'm saying that is we have statutory rape, right? That's 14 and 15-year-olds having willing, well, sometimes even under 14-year-olds have willing sex with an adult who's then charged with statutory rape. I don't think that it's meant to encompass those cases. If you're a willing participant, you can't just shoot someone because you don't like them anymore or because you want to kill them and then claim later that it's because they were about to engage in this willing relationship with you that you were already in. So yes, I do think that if we just put first and third degree CSC, it should suffice, but with the clause that it was, that there was no consent involved, something like that.
I don't think I've ever seen this section used in the almost 50 years I've been practicing law here. I don't think anybody's ever killed somebody trying to rape them, and certainly not a child. But to me, I mean, I think the definition of force and coercion undertakes the fact that someone is being manipulated. And so I was the one that objected to this back in October by just putting criminal sexual conduct. And I think what it does here to correct it is fine. I don't think we need to do anything else with it.
Just to respond to that, it is very rare, but I will say that just last year, and it wouldn't even be inclusive because it was only contact, but just last year we got an acquittal of a homicide because the defense was that the homicide victim was trying to commit CSC against the male. It was a male on male by touching his penis, or he did or was going to, and that is why he killed him, and then the jury acquitted. So it's definitely a rare situation, but it does occur. I don't, like I said, if we're trying to mirror the intent of the legislators when they enacted this, I believe the current amendment is fine. But I just want the committee to know that there are going to be situations that this will apply. And even though it has not happened on Guam, I have actually read news articles in the States about minor children who were subjected to repeated sexual assault. They killed their perpetrator, and then they themselves were charged with homicide. So while it's rare, these situations can occur.
Well, I think this intention is that it's the killing occurs when the assault is happening, not you kill them because they've been doing it over the years and they're asleep and you kill them. That's a completely different situation.
Right, correct. I understand that, but I'm talking about the situation where because it's a repeated sexual assault, you're not killing because it happened to you, you're killing because it's coming again, and there's no other way to stop it, essentially, is what the situation would be. But I agree, it is a rare situation, but that's what we're all here to do with the commission, is think of situations that are not, that it can be applicable to.
Any other comments? All right. Is there a motion to approve this as presented?
As written?
Yes, as written.
I move to approve it as written.
Is there a second?
Second.
Any opposed? There being none, it passes. Thank you. Thank you very much, all. Thank you for the comments. Thank you for the discussion. All right. What's next at this point? I believe our last presentation will be the Subcommission on Crimes Against Persons. We will table the other subcommission presentations until the next meeting. Attorney McDonald, you have the floor, sir. Go ahead.
Thank you. So we undertook review of 3 chapters. These were actually overflow chapters that we were able to review. Bribery and gambling don't necessarily fit into the crimes against a person, but let's go ahead. Family violence. So we reviewed all of these sections. I'm not going to read them all to you. And we didn't find any reason. We thought that the statute was working reasonably well. We didn't see any of these sections that needed any amendments or repeals. Next chapter. What we did find is in 30.20D, we believed that, and this is in reducing charges from a felony to a misdemeanor in the family violence statute, that due to unusual circumstances, a reduction of the charge is manifestly in the interest of justice. This standard of manifest interest of justice really does already encompass unusual circumstances. There were some comments and some of the other some case law that this might be a little redundant. So we believe that the standard for manifest interest of justice is sufficient, and this language doesn't really add anything to it. As put in the presentation, state courts consistently interpret manifest interest of justice as standard requiring clear, obvious circumstances that would result in fundamental unfairness if it were not granted. And so that fundamental unfairness really does encompass the unusual circumstances. And the tool is often applied without this language of unusual circumstances. So we believe that the inclusion of this language was not necessary, and it was just a minor removal of the clause just to get rid of any sort of indefinite or vagueness as to the application, and to give the judges, of course, more leeway in their application of the manifest interest of justice, and not to circumscribe that. Okay, so we looked, and there was a lot of discussion about 30.30, which is this primary aggressor statute in the family violence chapters. And first of all, there's the law remains on the books in domestic abuse cases, domestic violence cases amongst the states. The law remains on the books, and many jurisdictions do have this. I think our discussion more centered around policy. We weren't seeing, I believe, and I'll ask Christine to chime in if she wants to. We weren't really seeing this thing being applied, because what it requires is that the officer actually makes a judgment call on who's the primary aggressor, and then after making that judgment call, to document it, and if that's the case, to go ahead and after making that determination, arrest. So I just brought this out to say that, we didn't, after the discussion, it seems like we don't believe that this needs to be repealed. I just wanted to bring it up as a point of interest. It does remain on the books. Texas, though, knowing how unworkable it could be, what we did find was that Texas actually has, not in the criminal code, but a requirement as part of their public safety statute for education and training on how to determine primary aggressor. And so that's outside of the scope of what our review is, but just to relieve the tension a little bit on the discussion. Yeah, sometimes it seemed like it was unworkable or not applied, but one approach might be what Texas had, which is actually to include it, but not in the criminal code, but in the public safety code. Okay, let's go to the next slide. We also talked a lot about mandatory confinement, the concern being due process on mandatory confinement. We discussed whether mandatory confinement out of family violence, and having taken a number of these calls in the middle of the night on whether or not grandma, after
Candy.
Yeah,
13-year-old.
burning the cell phone, or destroying some of the cell phone, had committed family violence, and being asked whether or not we should throw grandma in jail. So we thought that these do need to be handled by the ones. And I think as a general rule, I think mandatory confinement does work. And when we did find that when the prosecutor's phone is on, and we do get the calls and answer them, sometimes the judgment calls are a little fine. But we believe the statute, despite some concerns about due process and just having to, on the report of a family violence, throwing somebody into confinement for a night to cool off, as a general rule, still, we think on the balance works really well. And none of these were struck as violations of due process or anything like that. It just goes back to whether or not there was probable cause, and those always were. Okay, next slide, please. So nothing really to report out, just the striking of the language of unusual circumstances.
Okay, so just to recap, the subcommission on crimes against persons reviewed the entirety of Chapter 30. Is that correct?
That's correct.
And the only change after the entire review was 3020 subsection D, unusual circumstances.
That's correct.
And then the subcommission also reviewed the entirety of Chapter 49, bribery, with no changes recommended.
No changes recommended.
And then also the subcommission reviewed the entirety of Chapter 64, gambling, and no changes recommended.
No changes recommended. The only, just to cut to the chase on the bribery section, public official misconduct is graded as a misdemeanor.
Yeah.
And on the balance, some of the conduct that could fall into it, like for instance, what you had in the Kenya, some of that public official misconduct was really quite grievous because it was under color of law. Right. And so for that to be only a misdemeanor, of course, there was other violations there, offenses there that carried the prosecution. But we just thought it would be a good idea to maybe make a recommendation now to consider a felony level violation on some of the other factors. High level officials involved in the conduct, large monetary benefits obtained, repeat offenders, and then violations of particularly important law, for instance, the law enforcement public official misconduct. And so we didn't have any specific recommendations to raise it because we know this would be a very large discussion and probably no justice to it in a presentation. But if the committee wants, we can come back with a more comprehensive sort of workable gradation. And I will also say that the states that do this, they'll have first and second class misdemeanors, right? More gradations of felonies and misdemeanors to carry the day on that, and not just the simple what we have here. And the other things that some of these other statutes had is you can see that some of these and it's not addressed in the criminal statute. You only have to know it if you are practicing the civil service law.
Yeah.
That if you did have a felony, so if you have a misdemeanor, that's not necessarily gonna keep you from getting a government job. But if you committed public official misconduct that was grievous enough, and it was only a misdemeanor, and it's not a bar to you becoming so there might be some policy reasons, and certainly we can come up with a more robust analysis of this, but just to let the group know that yes, public official misconduct, and outside of that one instance, I don't think there's been a successful prosecution in recent history.
No. If I could make a suggestion, I think it would be worthwhile for your subcommission to look at the range of penalties associated with this chapter. And we could have one of our research attorneys do extensive research on this and present it back to you.
Sure.
Okay. So then if I could suggest we table this chapter.
Table
Well, this section 4990.
49.
Okay.
Okay, just 4990.
Just 4990.
And I would like to point out that probably was inadvertent, but you missed 49.7.
Yes, no changes to 4970
Okay,
either.
no changes to 4970.
Which was what? I'm sorry.
It was
Accepting gratuities for past
I see.
services.
Okay, got it. Yeah.
accepting gratuities for past services defined and punished. No charge.
I'll also comment on just the academic part of this. Federal law is following what the model penal code did, which is requiring tit for tat as opposed to using corrupt, which had was very difficult to define.
Arcane.
Yeah.
Right. All right. So just to recap, family violence, there's no changes no change recommended except for 30.20D. Chapter 49 bribery was reviewed, no changes except for 4990, which is tabled. And chapter 64 was reviewed and no changes recommended for the entire chapter.
If I could, in chapter 64, I apologize. The commission I forget what chapter it was, but one of the recommendations we made was to remove cockfighting.
Yes.
From the animal cruelty laws as an exemption to the animal cruelty laws. But there is statutory language on gambling in cockfighting in chapter 64. Wondering if you wanted to take a closer look at that section.
Well, I guess in looking at the cockfighting, we were taking it from the perspective of a proscription on gambling, which culturally remains in the memories of a bunch of folks that are gajeras and whatnot. And so even though there is a federal offense
Prohibition.
and there's been many, lot of rumors about the feds cracking down on this kind, we haven't seen one prosecution. Now, does that mean it isn't going to happen? Well, who would have thought that bingo was illegal gambling? So if your question is, do you want us to, is there something specific in the statute that we thought from a gambling as a proscription perspective should be looked at?
I guess the potential conflict would be we've consistent with federal law, we've removed cockfighting as a legal sport.
as a legal sport.
as a legal sport.
Right.
But then we'd still have gambling associated with cockfighting as being legal under the statute.
Yeah. We
So-
could take a second pass at that, but I think we're gonna come up with the same recommendation, which is if it remains on the state books, I guess on some hope that the feds
But
change.
we're
their mind on
removing it
that.
though from ours. Our recommendation was to remove it.
Remove it as,
Take it out.
We've taken it out. The recommendation was to remove it.
we'll come back to the discussion then.
Okay,
So what section? 64,
6440.
6440 is also tabled.
Okay.
Is that correct?
That's correct.
Okay, so one more time. So, yes,
I have a question before you get too much further.
please.
In the family violence that you're kind of going without making any changes, did you discuss trying to deal with 3020, which says you're guilty of a misdemeanor or a third-degree felony, and just follow along with the statutes for assault and say if it's a personal injury, it's a misdemeanor. If it's a serious bodily injury, it's a felony, so that we don't have the same possible punishment for either a felony or a misdemeanor. If I slap somebody, it could be a felony or a misdemeanor. But is that a serious bodily injury? Did you guys discuss that at all? I was trying to clarify that.
I don't recall that we did discuss it, but we can certainly take that one back.
I can weigh in a little bit on it, Randy. I mean, there was a discussion about it. Obviously, it's my preference to adopt a completely different statute, but ultimately our Supreme Court upheld the current framework of this statute. So if our analysis was really, let's weed through things that have been touched by Guam Supreme Court or U.S. Supreme Court case law, then let's modify it. But ultimately, it looked like the framework had been supported by our Supreme Court. So the decision was made not to try to amend it.
Also, sorry, this is Christine. I'm using Valerie's because my phone died. Here's the other reason why. So to address Randy's concern, the way we actually charge it here at the AG's office, we actually, anytime we're charging the third-degree felony family violence, we're also charging the corresponding either aggravated assault or strangulation. So it's very clear that one is being charged because it's serious bodily injury or because it's the third offense, because those are the two ways to get the third-degree felony. So I don't believe that the amendment is actually necessary because we're doing what we can to ensure that we are delineating between bodily injury, which would warrant family violence as a misdemeanor versus the felony.
So in response to Attorney Cutler's question, there was discussion. It was considered.
Yep.
Yes.
Okay. Thank you.
Yeah.
Thank you. Okay, so just to recap before we vote on this, one more time, sorry to be a broken record here. Chapter 30 was reviewed, and the only suggested change was 3020 subsection D. Everything else, no change. Next was Chapter 49, bribery, the entire chapter was reviewed. No change except for tabling of 4990, which is tabled. Finally, Chapter 64, the entire chapter is reviewed. Gambling, no change recommended except for a tabling of 6440. 4970 is, 4970 or 4990?
4970.
I apologize.
I inadvertently forgot.
4970
Also reviewed.
and
I'm so sorry. No, that one was no change.
No change.
yeah,
Sorry.
okay.
49.9.
I just forgot to include it in the slide.
One more time. Just you're making them all get upset with me here. Just let me go through this again. Chapter 30, family violence was reviewed. The only amendment was 3020 subsection D. Chapter 49, bribery was reviewed. No changes recommended except for 4990, which was tabled. Chapter 64, gambling, was reviewed. No changes except for a tabling of 6440. Any comments? Is there a motion to accept the subcommission on persons review and recommendations? Is there a motion?
I'll make a motion.
Moved. Is there a second?
Second.
Is there any objections? The acceptance of what they have provided, except for the tabled table statutes.
4990 and 64.
There being no objections, it is hereby accepted and included in the final reading. Okay. At this point, thank you very much for the work of the Subcommission on Persons and Property. I understand there was quite a bit of discussion. Next meeting, correct?
Right.
Here. So please note that our next plenary meeting is scheduled for the 26th of March, March 26th at noon right here. Please, next slide, agenda item 7. Communications, I have no new communications to present. Finally, item 8, agenda item 8, is there any comments from anyone? Other than that, I want to thank everyone for the work that you've done and you are continuing to do. I understand it's quite a bit and it's taking a lot of your time, but we are advancing and doing quite well in terms of the amount you're getting through. I would encourage the subcommission chairs to please utilize, the Chief Justice and the Judiciary as well as the Executive Director have worked hard to acquire resources in the form of the attorneys that are supporting us, including our newest person, Attorney Hoffman Odegawa. Please, subcommission chairs, please reach out to the Executive Director and feel free to utilize and request for the assistance of the attorney support, which has now come online. You've been doing this on your own, and I want to thank you for that, but please, we now have the muscle to back you up. Please use it. If there's no other comments, I want to thank everyone for their work. And do I have a motion to adjourn? Is there a second?
Second.
Any objections to adjournment? Thank you all, everybody. I'll see you March 26th. Thank you, everybody.